Yes, please.
Item number 1.
With your Lordship's permission, Madam.
Yes.
Inadvertently, Madam, reference has been made to the plaintiff, but in the paper book, the plaintiff is absent. So that will be required to adjudicate this matter, because I will be referring to the prayers in the plaintiff, because that is the whole issue that comes up from there. So, Madam,
appeal from a decree.
no, it was against rejection of a plaintiff.
Lordship, it is not actually required, because I have also advised my senior friend that this is order has come out of the miscellaneous petition under order 711B. And
Mr. Counsel, on what ground your plaint was rejected?
Madam,
On what ground your plaint was rejected?
it was time bound.
Limitation of.
The limitation period for the suit has expired long back. So he has a one set of calculation. I also have a one set of calculation to show before this. And today, I think even if my relevance will not conclude.
The plaint is very much required,
Yes, Madam.
because it has to be shown from the face of the plaint.
Yes, your Lordship is absolutely right.
The plaint is nowhere there in the papers.
Illegally, reference has been made in the paragraph, but it was not annexed to the paper book. So even if my learned friend has difficulty, then we will have to produce the plaint.
Let us see the judgment.
Yes. Because your Lordship has to see the prayer in the plain. Page 213. Page 213.
let me, Lordship, should I begin or my learned friend will begin?
No, it is. I am just going through the judgment.
No, I'm just seeking your Lordship's permission. Lordship, here, as your Lordship was very much right when Lordship made a observation that this is not against a decree or money decree, this is against the order of the learned trial court in the commercial money suit number 11 of 2023. And after receiving the summons, they have come with the written statement and also a petition under order 711B, which was registered as Miss Case 2 of 2023. Now, naturally, Your Honor, that we have been asked to give show cause. We have filed our show cause there. And secondly, after the show cause has been made, there was a hearing, and on a trial court rejected. I saw that reviewed here on 13/12/2023 that the suit is barred by limitation. So my learned friend is right when he said that plaint is not there, but plaint is, I'm sorry, Lordship, I have not given the plaint because I thought that this is out of the miscellaneous petition. So petition, show cause, written statement is all there. And in the body of the memo of appeal, Lordship, I have otherwise what is the context before the learned trial court, I mentioned, Lordship. But if at all my friend, learned friend is feeling disadvantage, then I have.
Your Lordship is absolutely right with the proposition of law. If you have to make a case from the undisputed facts and the plain.
After this COVID period,
Yes, Madam.
what time you had in your hand? Is it 4 months, 21 days, or a longer period?
It is a longer period, my Lord. We did not come before this court because ultimately plain was rejected. But it ought to be more than 4 years. 4 months.
Why?
My Lord, if you are preparing the plea, what has happened?
What is the cause of action?
Yes, Madam. There was a contract for loading and unloading of trucks from FCI, from various railway stations in Guwahati to Shillong. So there was an order from the Honorable Supreme Court that so far the weight capacity of that the truck at that particular point of time was concerned, there was a limitation fixed by the Assam Police that you cannot put more than 15 tons in a truck. So the defendant expressed his willingness, expressed his intention to the Food Corporation of India, saying that this contract is now being impossible to perform and I could not perform it. So normally under Article 54 of the Limitation Act, once the defendant express or the party express the intention not to do the contract, the limitation period will start from the 3 years period will start. So here, it has been filed after 9.5 years. So these are all here, but we have to. I'm really sorry to interfere in the. I don't know why. You have your sense.
What is the cause of action?
A cause of action is that since they have done the work on the basis of at my own risk and cost, so they are claiming compensation as well as for the money paid to the other trucks which was engaged by FCI with interest.
No, what have you claimed?
No, I have not claimed. I was the defendant. I have only said that since the suit is time-barred, the claim should be rejected, and that has been. I have to confine to that. Yes. So I have to confine to the matter. This fair. This is not a trial court. No, I am not agreeing on the merit. No, you are right. No, I am only answering my.
The suit is by whom?
Suit is by a Food Corporation of India.
Yes.
They are the plaintiff.
Yes, what is their cause of action?
Their cause of concern is that since they have incurred additional expenses for hiring other trucks, and they have asked for compensation for that part. And they have done the work by other contractors.
Lordship, if I am kindly allowed, I'm giving my synopsis of my submission, otherwise it will be very easy to write the matter.
We will also hear you, but don't please take your seat.
No, my friend is going here.
I love prejudice my friend.
Please take your seat.
Limited question of
No, I'm only answering, sir, the question put by my Honorable Chief Justice as well. Yes, Your Lordships.
Then you got the contract, you terminated the contract.
No, but I expressed my desire not to do the contract because it is now impossible of being performed because the rate that was offered by FCI was not, it is not feasible for me.
They filed a suit to recover the risk cost expenses.
Yes, as well as interest. And it was time barred.
How?
Because the limitation period, if your Lordship looks into the...
From when they have calculated the approval of the cause of action?
They have calculated when they have terminated the contract.
Yes.
Even if you take it from the termination of the contract, then also there is delay. But here it will go beyond the termination, that the day on which I expressed that I'm not willing to perform my part of the contract.
That is which year?
2010.
And which year they terminated the contract?
2011.
And when the suit was filed?
23.
How was this period covered?
They say that there was a status quo order operating and there was a writ petition pending where there is a stay order. But those two orders have not precluded them from filing a money suit against us. Or neither they have filed a counterclaim in that suit for this part of expenses they have bought. Neither they have filed any suit for specific performance of the contract.
What was the status quo order?
The status quo order is that they have terminated the contract and they were about to take the consequential of the recovery. That has been stated. Your Lordship can see the status quo order, Manoj. Just a minute.
It's going in a reverse.
No. Just a moment. Status quo order. At page 69. Short order, last page 69, the last order. Typed copy is there, that's yes. But 69 is also legible. Till the next date fixed, the European communication dated 21/9/2010 shall not be given effect to. That communication you also will find at page 66. Page 66 is the intention of the FCI to do the contract at my risk and cost.
Clause X is termination.
Yes. Your lordship would like to see the termination clause.
No.
No. But your lordship will find that ultimately this writ petition was disposed of at page 72. This status quo order was vacated at page 72 prior to the filing of the suit. Before the limitation period starts, then before that only it was vacated. That is at page 72, 73. Writ petition and miscellaneous application are dismissed and the interim order stands vacated. Page 73, my lord. It's an order of 1910-2010. Title of suit order.
77.
Yes.
Then you also will see the order of the title suit at page 77.
Yes.
The type copy of the order is at page 78, my lord. Order to get efficacious, it will be it.
It was order for located 73.
Page. Page go. 73 2020. नहीं बोलो ना कहाँ है?
Yes.
Then this status quo order was vacated at page 80, my lord.
It's 79.
So they want to say that the limitation has initial period of 3 years has shifted to now to 2018. But in the suit, you also will find that there is no counterclaim. Neither they have filed any suit for specific performance of the contract. Neither they have filed for, they filed it for vacation. The order was, they kept it silent, saying that the judiciary has shifted from the executive to the judiciary in Meghalaya. That's why 2 years went on, that those excuses are there. So, your lordship, without the claim, it will be very difficult to show me the exact, because they have given some of the dates, but some documents are not there. That's why I was saying that today, even if it's...
You see,
Yes, madam.
these are kind of facts
Yes, madam.
which cannot be adjudged in Order 7, Rule 11 on just reading of the plain.
Yes, madam.
Now, what is the effect of status quo? If it is in the nature of an injunction, I think section 18 or 19 of the Limitation Act, that whole period will be excluded.
Yes, madam.
Then again that injunction is resumed.
Your lordship is absolutely right.
So you consider this, we will not stop you.
Yes.
Let it be tried as a preliminary issue in the suit. Let not the
Yes.
suit be thrown out.
Yes, madam, what I prayed before today, your lordship, today it may be due to paucity of time, I will not. Your lordship will hear me once, I'll place the facts, because I will not go into any dispute.
Because you will not be prejudiced.
Yes.
Because this question of limitation itself should not be tried on Order 7 Rule 11. This is not such a case that on a bare reading of the plaint it is barred by limitation go.
If your lordship looks into the sequence of dates in the plain, your lordship will be satisfied that it will be barred by limitation. I will not go into any disputed facts or facts which require adjudication.
It does not appear to be, because
Yes, ma'am.
the order of injunction was operative, then it went to the Supreme Court.
No, it did not went to the Supreme Court, because during the COVID period, they are referring to that Supreme Court period where limitation period was excluded for 2 years, then another 90 days was given. Then also, my lord, if your lordship will exclude
No, then the order of the trial court.
did not go to the Supreme Court. No.
No, Justice Lokur, what is
He was then the Chief Justice of Guwahati High Court, then that's why Justice Lokur's order is there.
Okay, vacated.
Vacated.
Then again,
They said that limitation starts.
then again the trial court. has restored the order of status quo, which
No, the status quo order vacated in 2018, then the limitation will start from
status quo order.
in 2018.
It's 17 and 18.
Where is that? Where is
80, page 80 starts, Malab.
No, where is that order written in hand?
Oh, that status quo order was of 2011, 22/8/2011.
Yeah, vacated in 2018.
Yes, Malab. From there also, your lawsuit 2023, again there is delay. And even while filing this appeal also, there was some delay. We did not point it out because on the point of limitation, we did not want
From 2018 also there is delay.
Yes, ma'am.
When was the suit filed?
In 23, date to question object. Give my note, paper book, notebook, small note. 7/5/23.
No, 2018 to 15th March 2020. What is the time period?
Yes, more notebook to this novel. Just a moment.
7/5/23.
No, who notebook to give?
That is the onset of COVID. Then
Yes, 2 years for COVID will go, then 90 days, even then also there is delay. And even by their own admission, they say that there is a delay of 4 days. In the, when they file a application, they said that there is a delay of 4 days
application where?
before the trial.
In connection with the suit?
Yes. If I am not wrong, my friend is not prepared.
So sure. You cannot have a section 5 application.
No, cannot. I will shoot, but just.
7/5/23 order.
Yes, brother.
Or if it, our latest technician, please.
Yes. Suit was filed on 7/5/2024.
No, between this,
Between these 2 months, 2 years will go.
High Courts.
no, 18 and 20, how many?
No, sorry. The trial court judgment, just a moment, my love. Trial court judgment or date to court.
Order date 70/2018 তার vacate করে দিছে আৰু 22 আমাৰ এন্ট্ৰি হৈছে সাকসেসফুলি
মানে এই ট্রায়াল কোর্টৰ প্লেনটো কেতিয়া ফাইল কৰিছিল?
You see,
Yes.
7/3/18
Yes, ma'am.
is the vacation
Yes, ma'am.
and 15/3 is the start of the COVID period of limitation.
Yes.
So that is 2 years, 1 week.
Up to 2 years, 1 week.
All right.
Yes, ma'am.
Now,
You'll also will find in the even in the interim judgment, the learned trial court has given the sequence very correctly,
in
ma'am.
the month of March 23 they filed the manuscript.
anyway, you file your supplementary affidavit,
Yes.
supplementary paper book enclosing the claim.
Yes, ma'am. And I have to give this sequence of that so that it becomes easier for the court, my lord. And as well as for myself. Huh?
But then if the facts are not admitted,
Yes, ma'am. Then you have no question. Then under section 18, your lordship can.
not 18, the question of limitation will be tried as a preliminary issue.
Yeah.
And not resolved or decided in a order 7 rule 11.
Yes, madam. That can also be done before taking up the other issues, my lord. But today your lordship will not pass that order. Your lordship will just give me time to reflect. I have another matter fixed before this honorable court on 23rd of my.
Because it does not appear to be a kind of a suit or a plaint which can be actually nipped in the bud.
Yes, that also your lordship can look into it.
That is, it is so bad that order 7 rule 11 go.
Yes.
It needs some consideration.
Yes, madam. Your lordship will examine it in the next date. In the meantime, I will try to file a rejoinder affidavit. We are bringing to record the plaint and this sequence of date as per our calculation.
They will file addition.
Plaint, they can bring it on record. Plaint is there, my lord, their cooperation. I can file a supplementary affidavit. No problem.
The addition.
Yes, sir.
Lordship, plaint, if Lordship directs, I shall give a paper book too, if need be at all, Lordship.
Let them file.
Let my learned friend file it.
Because of some of the documents which you have furnished to us.
All documents are given, no, you have to kindly study the case records, sir. Then you will understand.
Your corporation, you have the legible copies of the documents. I don't have.
No,
Even some of the documents are
Please agree on a date to hear of this.
I'll be here before your lordships on 23rd of this month. Short matter, another matter is there, so well, it's subject to your lordship's convenience.
Why not make it on 22nd, Thursday?
But Thursday, I met a fixed in Calcutta. I go there for these NDPS trial cases in Calcutta. Many Northeast boys and girls are all in jail.
Leave, on his prayer, leave is granted to learned counsel appearing for the respondents, stroke defendants, to file a supplementary paperwork incorporating the print with annexures and a list of dates relevant for the purpose of litigation.
Yes.
By
We can only just hold the points. It was supposed. Believe me.
14th May, comma, serving a copy on the advocate on record for the appellant stroke plaintiff. Next. List this appeal for hearing on 23rd May.
Yes, you are deeply obliged, man. Yeah,
Much of it.
Number 2.
Your Lordship's court has the most modern infrastructure in the country. I have seen all the cameras and all are very sophisticated. Obliged, Your Lordship.
Please, Your Lordship. Lordship, I am paying for an adjournment in this matter. Senior counsel could not travel from Guwahati, madam, due to some personal difficulty.
Yes.
I am paying for some adjournment in this matter. Our senior counsel, Mr. K. N. Chaudhary, could not travel from Guwahati due to some personal difficulty. Subject to Your Lordship's
Go on the other side.
convenience.
No objection. When
21st May, if I may pray, madam.
21st of May.
Wednesday.
on the prayer of learned advocate for the appellant, not objected to by learned counsel for the respondents, list this appeal for hearing on 21st May.
Much obliged.
The next matter, Your Lordship, is analogous.
All right.
What is item number 2? In one, item number 2, there are 2 cases.
All right. Then list these appeals two together, one order.
Much obliged.
Number 3.
Is this? This. Three appeals are there. All right. Yes, Mr. Paul?
Malad, I am on item number 3, Malad.
Yes.
This is an appeal, Malad, against the judgment on order dated 26/7/2024. Malad, we had filed a paper book. Malad, I'm sorry, there are some serious defects on the paper book. I've examined it today. I've also spoken to my friend.
But there are some mistakes in the paper book, my lord.
So what do you wish to do?
Malad, we'll rectify it, Malad. Kindly grant us a week's time. I'll ensure it.
File a fresh paper book. Or,
We'll file a fresh paper book, Malad, because that what unfortunately has happened, Malad, that the documents which were annexed as annexures in the before the single judge, Malad, they have been taken out, they've been marked separately. So that's creating a confusion for everybody.
all right.
If it may please your lordship, I'm appearing for respondent number 4 and 6. The leading counsel for the private respondents is senior advocate D.K. Mishra. Due to some personal difficulty, he couldn't be here in person.
We are not hearing the matter. Whenever we are listing the matter, ask him to be present.
Seeking your indulgence, your lordship, if the senior counsel can appear through VC because of his difficulties to be here due to...
All right, if the matter be listed 2 days before the matter is scheduled to be listed, please make an application to be...
Your lordship,
for
I will
leave to
write,
be-
your lordship.
Yes. Together with the grounds.
Your lordship.
it is common ground of both learned counsel that there are some inadvertent mistakes in the incorporation of documents in the paper book. Understood? Accordingly, leave is granted to the advocate and record for the appellant to file a fresh paper book by vendors. 14th May?
My lords.
By 14th May? When should the appeal be listed, Mr. Bozika?
The week after that, my lord, anytime.
List-
26th or 27th, my lord.
Subject to my lord's kind convenience, 26th or 27th, my lords. Would that be convenient?
All right. List the appeal for hearing on 26th May.
My lord.
The paper book already filed in court and in the records shall be duly cancelled by the registry.
Right.
Where to station? Issued by paper recommendation your lordship in this matter to review the conducting officers out of station.
May I please, Your Lordship? The case of the respondent number 5 become infructuous, so I pray that I may be allowed to file a miscase to delete the name of respondent number 5, my lord, because their appointment for 6 months has already been expired last year, my lord, November 2024. And the order we have challenged also, it is also become infructuous. So I may be allowed to file a miscellaneous case to delete the name of the respondent number 5, my lord.
Now say once again why you want to delete his name.
Yes,
Why you want to delete his name, please tell us.
this is case for, because that in order, case number 53, my lord, that is that.
My lord, my learned senior is trying to point out that the impugn order which was under challenge, my lord, the term of the impugn order is over, my lord.
So, it is in 53, my lord.
Yes.
Case number 53. Shall I read out, my lord? In pursuance of the notifications as and such dated 24th April 2004, Executive Committee of Garold Autonomous District Council Pura is pleased to appoint Shri Mahbub Sheikh, son of Abdul Jalil, as a Gambra of Galadagli Part 2 village, bifurcating from Boshibanda Gambra for 6 months with effect from 1st May 2024 to 30/11/2024. So, the case of the respondent number 5 become infructuous because we have challenged another order also, my lord, that will be remain before this honorable court, my lord.
Respondent number 5 was the repeat petitioner.
No, he was the respondent, my lord. Respondent in the petition.
Private respondent, my lord, not this Garold district councils.
His appointment was challenged.
His appointment was challenged and the appointment was for a 6-month period time, my lord. That has lapsed, my lord. Now, we have to find out, my lord, whether his appointment has been extended or not, my lord. If it has been extended, my lord, then again,
It is
all
not
options will be-
accepted, my lord. It is not accepted. I confirm that before this order.
Instruction, your lordship, because we are not aware that my appointment is extended.
You are appealing for whom?
I am appealing for the district council, my lord, for the authority, my lord, who has appointed the private respondent.
Who's for the writ petitioner?
My learned senior is for the writ petitioner.
I am for the writ petitioner, my lord.
So if the appointment is over, the term is over, then what is the consequence?
Now, well, either my lord district council will go for a fresh election or will give extension, my lord, till we go for a fresh election for appointment of Gawpura.
What he wants?
My lord, the grievances of the petitioner was this, my lord, before the single judge, my lord, was this, my lord, that the bifurcation of the village, he was agreed with the bifurcation of the village, my lord, and the appointment of the private respondent.
So private respondent is already become infectious and bifurcation order is under challenge, my lord, now, before this honorable court. It is in the page number 52, my lord, which is under challenge here, my lord.
So how are you affected by the bifurcation order?
Because they have done it without the let down procedure, my lord. Bifurcation, I am the headman of Bostibanda and Goladili Part 2, my lord. As per the Assam Land Law and Regulation, my lord, 1886, in executive instruction, that thing they have not followed. I have to give an opportunity of being heard. There must be the inquiry and opinion of the villagers, my lords. And I am protected. The Gambura, that is village headman, was protected under Article 311, my lord. That thing also they have not given me.
That is not the correct facts what my learned senior.
No.
He is holding any post.
No, at present he is not holding. There is no interim order in favor of my learned senior.
Because
My lord, the grievances that he has projected, my lord, is incorrect, my lord. He was given a show cause, my lord. He has replied even, my lord.
that one I will come, my lord, at the time of my argument, my lord. Because they have done totally against the law, my lord.
He wants to be the Goanbura.
He wants to be the Gawpura, my lord, the village headman, my lord.
I will continue village Gambura, my lord. But they have bifurcated my village, one village Goladili Part 2, my lord, without giving any opportunity of
That is
hearing.
not correct, my lord. That is not correct.
That is appointing another Goanbura.
Yes, my lord. And there was a need, my lord, and there was a demand made by the villagers, my lord.
No, it is not like that, my lord. There is,
Because after going through the record, my lord, has passed this order.
there is no rule, my lord, for bifurcating the village under a Gambura, my lord. They cannot show. District Council. Anyway, my lord, I may be allowed to file to delete the name of this respondent, private respondent number 5, my lord. And we will challenge only the bifurcation, that is 24th April 2024 by the Garowe District Council, my lord.
There is no need of filing an application. If he endorses the fact, we will deal it.
My lord. That is what my lord, instruction has to be taken, whether his appointment was extended or not, my lord.
It is not as extended, my lord, I have confirmed it.
We have been referred to the office order of the Garowe Hills Autonomous District Council, to the Land and Revenue Department, dated 15 May 2024. Appointing the respondent number 5.
5, my lord.
5
Yes, my lord.
as Goanbura, Gaon, Gaonbura, Gaonbura, Gola Digli, Part 2, Village. See page 53. Bifurcating it. No, from a bifurcation of Borshibanda Gaon for 6 months. Paragraph, this appointment is the subject matter of challenge in the writ petition. Along with the issue of bifurcation. Paragraph. We direct learned counsel for the respondent number 1 to 4 to seek instructions whether the respondent number 5 continues on any extension or his term has come to an end on 30th November 2024. When should we list it?
After 2 weeks, I will take the instruction.
Don't make it 2 weeks.
Let it be then after 1 week, I will take the instruction.
List this appeal. On 20th May.
Number 5.
You have served.
My lord, even the paper book has been provided, is ready, my lord. Well, this matter will take some time, my lord, because there is a long checkered history in this matter. But here what happened, my lord, the respondent who was serving in Assam Rifles, my lord, he opted for deputation to National Police Academy in Hyderabad, my lord.
When do you want us to hear? It will take time.
It will take some time, my lord. Because the facts are spanning over 15 years, my lord, and there are several rounds of litigation in between. So some writ petitions were filed before the Hyderabad, Andhra Pradesh High Court, my lord, and parallelly writ petitions were filed before this honorable court, my lord.
Both learned counsel agree that hearing of this appeal will take some time. Hence, list this appeal on 16 June.
My lord.
2025.